Okay, I think we should just crack on, but whoever wants to grab themselves a cup of coffee or use the bathroom, please feel free. But I think in terms of time, we might just crack on to our second panel. So my name is Jia Hong Chen, and I'm a lecturer in law at the University of Sheffield. So it's my great pleasure today to chair the panel today. So in this second panel, we have James MacGregor, Akbar and Natalie Leesakul. Just like what we did in the previous panel, I'll let the panelists introduce themselves, and then we will kick off with the questions. James.
Hello, everyone. I'm James MacGregor. I'm the founder of a business called Ethical E-Discovery, which is a consultancy firm which works with law firms in the management of digital evidence in the context of investigations or litigation. So I deal with large data sets when there's a need to maintain chain of custody of evidence from collection until they might be produced at trial. I've been in the legal tech space for about 15 years. I was at big consultancy firms before I started my own business. And in terms of my relationship with AI and legal, so the e-discovery industry has been quite advanced when it comes to the adoption of AI. Technology-assisted review, machine learning has been present for my part of the profession for at least 10 years or so, based on legal precedent. And obviously, with the advent of ChatGPT, now using generative AI to do document review has exploded. And so many of my clients have regular questions about that. And I chair the working group of the heads of litigation technology at many of London's biggest law firms, where we're trying to put together a best practice guide in order to use AI in the context of e-discovery, e-disclosure.
Akbar started off life as a technologist after a computer science degree, leading development teams for UBS and building various platforms. Then saw the light, as you do, and decided to become a derivatives financial services lawyer. I was at Allen Overy for close to 6 years, and then saw the light again and tried to put the two together. So I started D2 Legal Technology. That's a consulting firm at the intersection of fintech and legal tech in 2011. We're about 100 people globally across London, New York, Hong Kong, Singapore, Sydney, etc. We advise typically in-house legal functions or banks, I would say, because typically it's a business problem as opposed to a legal problem that we're helping them solve, on digitalization of, well, you know, just how they might look at things from more of a data view to solve some of their business problems. And obviously that takes you very quickly into AI. Actually, the first project we ran ultimately advised Credit Suisse on the spend in 2011 of 120 million US dollars on an AI tool. And yeah, plenty to be said there in terms of that sort of spend bit back in 2011. So that's the kind of the main role. I'm also the current co-chair of the Technology Law Committee at the Law Society, and a professor at the University of Surrey, teaching AI to the technology master's students, but also areas such as AI and ethics and cyber law to the final year undergraduates at the School of Law.
All very impressive profiles. Hi, everyone. I'm Natalie. I'm assistant professor in Law and Autonomous Systems, School of Law, University of Nottingham. I have worn several hats. I did work for private sector, public sector, but I'm currently, my areas specialize in AI robotics regulation and specifically more focusing on the adoptions element. I guess more maybe fit from you. So my background is actually in business law, and then my PhD was actually in computer science, looking specifically at human-robot collaborations and the role of law to help drive the adoptions in digital manufacturing sector. And you might think, why am I here? Yeah. So I actually have worked in various sectors, from manufacturing sector to ad tech space. And my recent projects actually were looking at the use of LLMs for legal advice. And that is why I'm here with you today.
Thanks, everyone. So this second panel, we are going to focus a little bit more on the regulatory and ethical aspects of using AI in the legal sector. But I think that follows quite nicely after what we just discussed in the first panel, especially around, for example, how do we avoid benchmarking being sort of aligned with commercial interest, or even the wider regulatory capture issues where, regulators might just, focus on getting things approved rather than making the benchmarking and evaluating LLM systems meaningfully. So I think I'll start with a question that is kind of open, and that might also touch on a lot of things we've been talking about today, which is when we're talking about adopting and using generative AI sort of in a ethical, compliant way in the legal sector, what sort of barriers are we experiencing? Can I bring that first question first to Akbar, because I know you've been doing some work engaging with law firms, especially the smaller size law firms in the sector. So do you have any insights into that?
Lots of barriers. And one thing I picked up earlier was this this worry that we are potentially creating a two-tier legal system, the haves and the have-nots in terms of what they can do. But actually, taking a couple of steps back, the biggest barrier is the skill sets and the lack of upskilling for me. And I think there's less excuse when you look at the city law firms and the resources they have at their disposal, and it's a problem there as well. It's a massive problem when we start looking at small and medium-sized law firms. It's tricky because a day doesn't go, there's not a day when we have a new announcement about this law firm using this AI tool, and Richard, if he's here, certainly helps with giving some of the visibility there. But it's there's the kind of FOMO. But what no one seems to be worrying about is making sure you know how to use these tools, and actually just even whether you need a tool and which tool. The challenges over upskilling are as dramatic as people say I want to use AI. And I'm quite glad you used generative AI as part of that question, because when people use AI, that of itself is a problem. I mean, it's such a broad collection of tools. I go back to, as I said, I did a computer science degree, and learning about AI in 1997. We were taught very early on about good old-fashioned AI, and then neural networks, and predictive AI, etc., etc. It's like someone's. There isn't a word for bike. There isn't a word for plane, and then we ask. So, there's just one word of transport. And then we ask someone, hey, is transport, how does it sit in terms of sustainability and ESG, etc.? And we try and answer the question. Well, what do you mean? Do you mean using a bike? Do you mean walking? Do you mean taking a plane, a private jet? It's as fundamental as that the skill sets aren't there, and then we're trying to say, let's pick the tool, let's use these. And I'd love to be at a point where people have that maturity to use some of the benchmarking tools and assessment tools that we're talking about, and getting into not just precision and recall and F-scores and all of that kind of lovely stuff. But the reality is, even at the big law firms, even in the big in-house functions, I see it being a million miles away from that. The survey you talked about, so we've just surveyed, we spent about an hour and a half we've insisted on the managing partner and the CTO type figure if they exist at some of these firms, and in many cases it's outsourced, and asked questions in 3 areas, probably about 100 questions, that starts with digital foundations. That's like, how do you store your emails? Where do you store your documents? Just general kind of broader legal tech. Then ask about their processes and workflows, and then ask about their AI strategy. And it's fairly disheartening what you see, and you can see why someone turns up with a shiny tool. And the phrase that I'm increasingly using is saying, look, a fool with a tool, still a fool, unfortunately, just with a lot of regret spent and feeling a hell of a lot poorer at the end of it. And it's a tragedy, because these tools can absolutely help, right? But you've put yourself back for another 10 years where you're not going to touch these things, because, and actually a lot of the blame goes directly onto the vendors. And how often is it the fact that the tool does what it does. It's just that working through the process and thinking those things is really problematic. And we're in real danger of, I mean, coming to the regulatory piece of this, you know, I see the other aspect here is the regulation isn't focusing, you know, the SRA and others, and I need to be careful what I say, given, these are not the views of the Law Society. We need to be careful. You know, we are sleepwalking into regulating the profession by enforcement and striking people off, et cetera, and not focusing on the skills, the mindset, the digital literacy that we need, understanding data, understanding process, how to put human in the loop as part of it. And just, if I may end just with a kind of, just yesterday, off the back of the survey, we interviewed a sole practitioner law firm. You know, actually her family kind of help out, but pretty much just this lone solicitor. And as part of the survey, she was asking about, the tools, and she said, actually, we've got a problem. Okay, well, my son told me that I should use ChatGPT, so I did, and I did it, and you all know where this story ends, right? I used it to prepare the litigation matter, prepare a bundle into the court, and it was really good. It's just that the citations didn't really exist. And it's been an absolute tragedy since that moment. So the other opposing side, kind of as they would, raised all sorts of issues with it. The client's matter didn't get dealt with. She's worried about about being struck off as a result. I know it's easy. In the previous panel, we said, well, just click on the link. You know, when ChatGPT gives you that link didn't necessarily exist, right? Again, it's about education, understanding when to use it, when not to use it, what you need to check. It's so good at the beginning bit. The reality is, in November 22, if you saw ChatGPT, ask yourself the honest question: is it a fair expectation that you would have thought it hallucinates? And I genuinely don't think a lot of us would have passed that barrier, right? She's got depression. It's actually quite scary how many of these instances we're seeing. So the biggest barrier coming back is the skill set and mindset for this new world.
I think that's a very great point. James, do you have any?
Yeah, well, actually, I wanted to answer Rob's question from the previous panel. I appreciate that it's the wrong panel for it, but you'd ask, I think it's relevant to this question as well. You'd asked why someone might choose Clifford Chance over a high street law firm, and is the value in the billable hour different? And I mean, the answer is maybe, but the reason why someone chooses a Magic Circle firm is because lawyers are obsessed with risk. All a lawyer cares about is, how do I mitigate my risk? And it's for the same reason, and I agree with everything that the previous panel said about the billable hour, and that it's a barrier to innovation, but it's also why the billable hour still exists, is because when a lawyer is operating, they do so not wanting ever to be the first person leading, because that opens up the risk, and so you hire Clifford Chance because you're being sued, or there's a massive international investigation, and you want to say that you chose the most expensive law firm for the job, because that means that if something goes wrong, your risk is mitigated. And I think it's also the biggest barrier when it comes to engaging and using AI. I mean, I don't take the dystopian view that Richard proposed earlier, which is that all law firms are ultimately just trying to cream as much money from their clients as possible. I think that lawyers are terrified of engaging or doing something which might open them up or open their clients up to unnecessary risk. And so, I mean, I guess to link it back to this project, I can see the value of external benchmarking, but I think that the challenge you've got then is that still doesn't necessarily protect their risk. I think, by being able to point to an independent third party and say, we've used this particular piece of software or technology because it's been benchmarked and we know that it's the most effective, you still want a tried and trusted and a track record, and you want legal precedent. And I think that's the biggest barrier.
Natalie, do you have any thoughts you want to share with us on this one as well?
Actually, I'm waiting for your second questions, which I think I'm going to tie it into this. Just kind of bear in mind on that. But I think when it comes to barriers, I agree with both of our panelists and also all the responses that we're showing earlier. Accuracy is one of them. Actually understanding how the technology, the capability of it, the limitations of that as well, and not even having to go to a legal professional just yet. Just staying with my students within the law school. I'm speaking on behalf. I'm not speaking on behalf of this law school. I'm speaking from my own perspective. But in my modules, I actually allow my students to use AI as part of the assessment, not the whole entirety of the assessment, but 20% of the assessment. And essentially, I think it's still really important to actually educate them on the limitation of technology and why it's so value of things that we're doing within the law school, where you actually need to apply your own critical thinking, your independent research work. So as part of this assessment, I actually allow them to, so we give them two prompts, either summarize an article or summarize a case law. You have to give us a summary of either one, and then your second part of the task is to critique the strengths and weaknesses of the responses and the tools that you use. And we encourage them to use the free version. And in this context, it's actually really interesting that strong students actually would read the case or the article themselves, therefore they'll be able to critique the strength of the answer provided by the model, whereas weaker students just rely on the summary and sort of just saying very genetic things like hallucination. However, we did see some students who didn't even realize that the LLM, the model that they chose, summarized even the wrong case. So I think it's really quite interesting when it comes to, even though we did try to teach them in class of what are some limitations that you need to be aware of, but one of the things is maybe also accepting that technologies do have flaws and limitations, and how do we actually educate them in the best way possible.
And I'm going to steal some of those ideas for my modules next year. But I think you raised a very good point about in terms of upskilling future lawyers with the skills they need for using AI in a sort of effective way, but also ethical way. There is this question of who should provide that kind of training and support. Is there a role for law schools to do it, or is it more of the role for the sector or for regulatory or professional bodies like the Bar Council or the Law Society? So I would sort of just encourage everyone to think about it, and we might be able to come back to that. But for now, I think we can just move on to our second question. So thank you for being patient with me, Natalie. So so the second question is in terms of what is good quality AI generated outputs. I know it would depend a lot on the task, but also it would depend a lot on who the user is and what sort of use case we're looking at. I know you mentioned you've done some work in this space, so I wonder if you have any sort of findings or insights that you could share with us on that.
Absolutely. So in terms of the output that you're expected, I think this has been discussed significantly already throughout this whole workshop, which is accuracy of it. But I think it's also interesting as well just to see how lay people are actually using LLMs or the free version of it, especially. So as I mentioned, one of my recent projects are called Regals. It's an interdisciplinary project within TAS, Trustworthy Autonomous Systems Hub. And in this case, we were actually exploring how non-legal experts and their willingness to use LLMs for legal advice. So we conducted a few studies on this. In the very first study, just to kind of, test the water out, we were looking at how currently whether or not general public are using LLMs to generate, just only generating, whether if they even attempt to use LLMs for that. So we did find that 17% of our participants did use LLMs to generate legal advice before, and they did say that 45% of them would be somewhat or extremely likely to use it again in this context, with the top 4 areas being property, planning, traffic law, and tax law. So we thought, okay, that was interesting. Only 17% of them say that they have tried using it before. Now, the next question is, well, just because you're getting the answer, are you actually going to act on it? And that's why the second part of the study was really interesting, and the results were very surprising as well. So before giving you all the results, for the second study, in trying to understand their willingness to act on LLM advice, we did an experiment. One is to just really understanding whether or not they're going to act on it based on the advice provided by LLMs versus the lawyers. And the second one is just to really see whether or not they know who generated the advice. So in the first experiment, we divided participants into two groups. The first group were giving the prompts, which is a scenario of what are the issues, and then they provided with two different advices. That first group, the source or no, we actually told them who generated the advice. And then we asked them their willingness to act on either of the advice. And the second group, actually, they were providing the same advices as well, but the source were unknown. Interestingly, in the experiment, we actually found that when the sources are unknown, people are actually more significantly willing to act on the advice provided by the LLM, as opposed to the lawyers. And when the source are known, the responses are more or less similar, with the LLM being just slightly higher, but not significant enough to actually draw a conclusion on that. Though the unknown one was really interesting. So when we actually test to see, well, okay, could people actually tell the differences? We did find that people could tell the difference between LLM-generated advice versus lawyer-generated advice. So therefore, even when the source were unknown, we suspect that people could still tell, and therefore they're still willing to act on the LLM advice. So I think in this case, drawing back to the questions of who should be using it, how they should be using it, it seems like people do trust the LLM response, right? And I feel like either they don't understand the potential limitation, because we know for a fact that when we were running the prompts and the responses generated by LLM, we knew that there were many mistakes on there. And we actually even have to tweak the prompts in a way that the LLM will generate the advice that would sound more or less similar to the legal, to the lawyers themselves. Why? Because when you actually ask LLM, when you give them just a general background, the default answer, when we use ChatGPT, the free version, they just automatically, the default jurisdiction is the US, which usually when you speak to a lawyer, the first question would likely be, where are you based, right? Where is this happening? But in this context, so then we had to tweak it. And we also realized that when you asked LM to actually provide legal advice, it always ended with, you may want to consult a lawyer, which is fair enough, but we had to obviously take out that part, so it's not too obvious. But all in all, I think prompt creating is also important, but also this study shows that lay people, despite knowing that they're LLM generated advice, they are still willing to act on the advice. And this is why it's so important to make sure that the models do provide accurate answer, and all the benchmarking and evaluations that we have been talking about all day today.
It's quite interesting that, it almost sounds like there's some sort of biases against actual human lawyers, isn't it? Akbar, do you have
come
any?
in there? Yeah. So I mean, I'm not a big fan of our flight towards saying, well, what's the quality of the AI? Because we need to look at it, and I think, coming back to the skill set we need, the mindset we need, about the process we put it in, and saying, with the human in the loop, etc. And I can give you a good example of that, right? So, we had helped one of the banks design a system. It was responding to a regulatory issue. They needed to know whether there were issues on the use of collateral within financial contracts. This is the fastest way to get fined if you get this wrong, with a multi-million-pound fine. And the problem is that we were focused so much on building a system that got to 99.9% accuracy. Where's the problem there? Well, the human we put reviewing it kept falling asleep at the wheel. You actually needed a system that kept them awake and would check those sorts of things. So, it can be very misleading, and we jump to this idea. Again, it comes back to, what's the end goal here? What are we trying to solve for? It's not about getting an accurate AI. It's about getting to the right answer or the right advice or the right kind of data coming out of it in many ways. So yeah, just let's not lose sight of that and check what we're trying to do ultimately. And it's not just the tool, it's the process that needs to be addressed.
Yeah, I completely agree. And I suppose, so in my line of work, and just to provide some context for those of you that don't understand or don't know much about the mechanics of disclosure, generally, when disclosure consultants are involved in a case, it's because it's time to review all of the evidence that might be relevant to a case. So you have large swathes of data that you need to collect, and lots of that's going to be irrelevant, and you need to use technologies in order to whittle it down to what you've agreed with the other side is likely to be a reasonable pool of documents for them to determine what is relevant or not relevant. And so in that sense, the task of the AI is to determine relevance. So it's a binary decision ultimately. And in terms of a quality AI output, all you're looking for is something which is as good as a human ultimately. And to your point, I mean, humans make mistakes all of the time, but you know, prior to us using any technology to do a disclosure review, invariably a human would code a document as not relevant when it was in fact relevant, or privileged when it wasn't in fact privileged. But that was just accepted because invariably mistakes happen. And so I think the same is true when you're trying to validate an AI output. You know, mistakes will happen, and you're not trying to reach a perfect solution. But ultimately, is this going to be more efficient, and is it going to be as good or better than a human?
So if we're thinking about the sort of cost efficiency that AI tools might bring for the sector, would we even accept a threshold slightly lower than human sort of lawyers or paralegals might have achieved?
I mean, I suppose that goes back to the business of law, doesn't it? You know, the challenge is that law is a business as well. And so if you're talking about using AI in a context of access to justice, so how to achieve the objective in as cost-effective a means as possible, absolutely. You don't need a perfect AI solution. You just need a defensible AI solution. You need to be able to, if you're in front of a judge, be able to argue that the process you followed was reasonable. And it's written down in the practice direction when you're negotiating in terms of, again, I'm talking purely from the mechanics of disclosure, that as long as you have taken a reasonable and proportionate approach to the value of the claim, then that is defensible. So yeah, you don't need a perfect solution. You just need something which is cost effective and that you validated and tested. You know, if the AI has made decisions, you still have the human in the loop. But ultimately, there's no reason why you shouldn't adopt a far more efficient approach. The challenge comes, at least in commercial litigation, because it's big business. And you know, this is again where I somewhat agree with the point that Richard was making before. You know, these business models are built on lots of juniors and trainees being billable for 8 hours a day. And if you have tools which now immediately eradicate that model overnight, then you undermine entire businesses.
We need to look at it bigger picture though, right? Because equally, we're not going to have anyone left who knows what they're doing, right? I mean, all the stuff that I trained on is going if we're not careful, right? And it needs people to, therefore, law firms to take the more strategic view of saying, well, what is the task going forward? And I think where we'll come out is the fact that this is not, and I think your question phrased it as kind of man versus machine. No, it's man and machine, and understanding how we work together. And actually, it takes me back to a conversation I was very fortunate to have, gosh, probably about 17, 18 years ago with Gary Kasparov, who some of you may remember was the grand chess master that kind of fighting Deep Blue and somewhat kind of fighting the last grand chess master that could say humans are better type thing. And you might say this is because he lost, but in the discussion he said, look, Akbar, the focus has been on man versus machine. That's not even an issue anymore, right? There isn't, the machine will always beat the grand chess master at the moment. That's not even just by brute force type thing, right? And we're losing focus of what we can achieve with man and machine. And in law, that's got to be really important, because otherwise we're going to introduce all of these other issues, like the lack of learning along the way, albeit we're trying at the universities, as we heard, et cetera, understanding the process and building, for the better and brighter future.
Just a quick thought on this. I think at the end of the day, depending on, what task you consider using AI for, right? I think how I see it is these are assistive tools. They're not here to replace, but it should actually complement humans. And I think this also coming a lot from my background, where working in manufacturing, and I trying to push for human and robot collaborations, not automation, not full automation to replace people, but actually to utilize technology to help we do our job, and to support us, but not to replace us. So I think when we thinking about certain barriers, and I really agree with you that we don't want to end up to the point where none of us know how to do anything, and we do see that with ironies of automations and before. So I think it's important to keep that in mind as well, of what technology is good at, but how do we actually use that to complement what we are already good at.
And I think the other important human factor in a law firm, going back to your question about why you would hire a Magic Circle firm, is because it's the relationships. The reason that you hire a Magic Circle firm is, particularly if you're embroiled in an international investigation, is that many of the senior leaders at that Magic Circle firm have strong personal ties with the people like the SFO, the FCA. Many of them will have been on the prosecutorial side before they then went in-house, and you certainly see it in the US. All of those major, former attorney generals end up becoming lawyers at firms like Covington and Burling, etc. And so, and I suppose, again, that's kind of verging on the challenges and a barrier that I think you have when it comes to AI adoption, because the practice of law is still very much a relationship business. Again, I think Richard described it as a colony relationship almost between the in-house lawyers and external lawyers. And that's definitely true in terms of how those relationships exist. And I think it's also then why you hire a very expensive law firm, because that law firm has the relationships that are going to be useful to you when it comes to the management of the case.
If I can just give a bit of a counterweight to that, though, right? I think I can see that, and I'm assuming you're not at Clifford Chance at the moment, right? No. From the answer. We always rush, though, to make things and just worry about the legal problem. And when you take a step back and say we're solving for business problems and then what AI can do, I think it takes you to a different space, because I think it's not just about what the big law firm can do, but also it really empowers the in-house function because of the data they've got to give context to some of that legal information and data. So I think, I don't think it's necessarily just, the big Magic Circle law firm that is the answer here. I think it's, increasingly going to be about the people that understand the data that really fuels and gives the business value from the AI. And I guess just an observation is that talking with law firms, small, medium, and large firms, as well as in-house functions, the one thing that I'm constantly surprised by is everyone wants great AI, but no one's bothered about getting great data. And what is it about it that we haven't understood, that actually the foundations of AI is your data, and we're just not going to get to a better place without that.
And I think a major sort of concern around that is obviously, privacy, confidentiality, and then they do want to keep the data and information safe, which perhaps lead to my next question about complying with some of the regulatory or professional sort of requirements, whether that is an in-house sort of function or whether that's an external law firm. So James, can I bring that question to you, especially thinking about discovery kind of work, because I think that's a very important part of what a lawyer would do. And in terms of thinking about humans working with machines, what sort of steps do you think we should take to make sure at least it's complying with some of the standards that
So
subject to?
sure. So, I mean, the previous panel talked a fair amount about regulation as well, and the challenges with doing so, because who are you actually regulating? I mean, I would say that there is already regulation in place in order to ensure that lawyers are following good practice. You know, whether if it's the SRA, you know, if it's the bar regulator, these regulations already stipulate that you need to be acting in the best interest of your client, and as such, you should have a knowledge of the tools and technology that's available. So I think the regulation is already there. I mean, at least in a discovery specific sense. So I found that certainly more junior lawyers in the profession are really excited about the technology and they want to use it. And at the moment, the regulation hasn't caught up. When it comes to the practice direction, it's not, the practice direction is too opaque in order for you to properly have a conversation with the other side about how you're going to use technology. And I have found that there are teams of lawyers getting together across different law firms who are lobbying the practice, the Civil Procedure Rules Committee, the Master of the Rolls, members of the judiciary, in order to try and adapt and change the practice direction such that it is now fit for purpose. And obviously the challenge is that the technology evolves at such a pace, and so, you know, the practice direction obviously needs to be sense checked and takes a while to develop. But I think you're seeing hungry lawyers who are keen to use the best tools available for their clients, actually helping regulators make that change in a way that's therefore possible and encourages the adoption of this technology. But in terms of new regulation, as I say, I think that lawyers are already regulated, and I would argue that regulation requires them to have a decent understanding of this technology already.
So, Akbar, I was actually going to follow up on that with you, because I know you're part of the Technology and Law Committee of the Law Society, and the Law Society has published some guidance for lawyers, well, for solicitors, in terms of how to approach using AI in their work. So from your perspective, do you think that's a helpful sort of approach?
I'm one of the authors of the generative AI, so certainly hope and feel it's helpful. But I think there's a gap in terms of people being able to use it and understand it. And I don't think there's enough of an understanding about what the expectations are. I think there's, I do put e-discovery in a slightly different space. I think it's a lot more mature there. I think it's a lot more clarity around what you need to be doing and what is okay and what isn't. When it comes to other areas, I think it's very vague. You know, how much do you need to know around data and data quality and bias and discrimination? How much do you need to know around the different models and how they work? How do you know that actually using a generative AI model to ask the question 1, 2, 3, 4, 5 times 1, 2, 3, 4, 5, by the way, it gets it wrong because it's not a calculator. I think there is a real challenge there. You know, coming back to what I said at the very beginning, we're sleepwalking into setting expectations by striking people off or kind of being on the front page of the Law Society Gazette type thing, which is not the way we need to go. And it needs to be around in the same way that, you know, I remember having to, yes, as part of the LPC, you need to do the solicitor accounts and make sure you go through all of that. You need to set the expectations to get the digital literacy and maturity that we need around all of it to set the human in the loop type expectations, etc., etc. We're certainly not doing enough, and I think the danger is that we give ourselves a pat on the back because we produced some guidelines that out of date already, because we've not gone far enough back to say, well, how do we address this going forwards? And actually, just if I come back to the university piece, I don't think we're doing enough in terms of the people coming in, and really applaud what you're doing in terms of getting them to use AI. But, you know, I find that equally there's a big problem in education, and there is use of AI in, you know, outside of academic integrity and I think we've also got people, we're just not guiding people at every stage enough as to what to do, unfortunately.
I agree. I suppose I think the obvious solution is that law firms should hire more technologists. I think that there are plenty of lawyers who are perhaps not technology literate, but I do think they have a responsibility to be so. And I'm not suggesting that it should be punitive. I agree. You don't want the stick to be the ruling factor, but I think there's an obligation on them to upskill or hire external talent in order to cover that knowledge gap.
I guess if you've got a stick, make sure you know what the stick is. And I guess what I'm saying is it's not clear because for me, it's not clear. You know, we're relying on existing expectations. And one question that's being posed at the moment is, what's the duty to disclose to your client around the use of AI? And I think you'll find that there isn't clarity there. There's an expectation from some of the banking clients that I have around law firms getting cheaper by using AI. They're only now waking up to the fact, oh, by the way, can you tell us exactly how you're using AI and which models and your processes around that, etc. But that's just one example where, I mean, the Texan court post Stephen Schwartz has now put those guidelines in place. But again, happened because Stephen Schwartz got disbarred, and then we moved to this world where, well, if you're putting a bundle into the Texan court, this is what the rules are.
I think the key message I'm getting from this is instead of heavy-handed regulation or enforcement, maybe we should really think about how to educate and train the next generation of lawyers. I remember a few years ago, some law schools actually started offering coding modules, optional, for law students. So Natalie, from a sort of, we're both sort of lecturers at university. So from your point of view, what do you think our curriculum could do?
Well, I think it's really important, as I already trying to expose my students to, is actually, we should embrace the technology, right? Like, I think the fear of us being replaced by technology, in my personal opinion, in my humble opinion, I don't think we're there yet. I can't promise you the next 100 years from now, but currently where we stand, this is where we should be utilizing technology for our to actually help us. So it's about embracing it, but you need to also understand how to use it properly. And I do absolutely agree with you in terms of actually exposing them to potentially not all the way to coding, but actually teaching them about all the different implications of the technology. So in one of the other modules that I convene, I do actually take my students to computer science and expose them to different technology and to actually talk to computer scientists so that they understand all the different developments that are happening recently. But I just want to quickly touch on the last point about regulation. This is a bit of an unpopular opinion, I would say, but I think it's quite interesting as well to see. Of course, there are certain code of conduct practices, how lawyers or legal professionals should do, and that should already cover the use of this kind of tools as well. But at the same time, I always wonder whether or not it should also be regulated. The actual product, the actual tools itself should be regulated. And when you're thinking about the guardrails in terms of this type of technology, does that mean there should be some sort of not just only standardization, but actually the hard law to govern that as well? And I think about it a lot, especially I have quite a number of students who were looking at legal tech, and one of them was actually looking at legal tech in M&A process. And we actually got into this conversation about, well, that is probably general purpose AI, right? But then at the same time, it's really depending on what the tool are being used for. If it's being using in, contract management, trying to analyze certain documents, doesn't deal with natural person, for example. But what if the tools were used, which actually not what if it was used, and I'm not even sure if it's still being currently used, but I remember in the mid 2010s, law firms starting to use predictive models to understand whether or not the case that they're taking are likely to win. And therefore, that could influence whether they would take you on as a client. Of course, that can be a bit under an ethical term, and nobody's going to come forward and actually say that. But journalists did figure out some firms were doing it. So I think that's why it's so interesting to see in terms of if it's just for a general purpose, maybe we don't need the hard law to do so. But as you will see with the EU AI Act, there are certain ban practices that need to be considered, and whether or not we need to kind of reflect back and think about how those tools are being used, who are using them, and what are the purpose of the tools. So I'm going to hand this back to
So much to think about and so little time. I'm just conscious we are already overrunning. I noticed a question from Slido, which is a great question, I think, in terms of standardization of evaluation. But I think we can maybe leave that question with everyone, and then I hope on future occasions, we might be able to reflect on that collectively as well. But can I wrap this up by thanking all our panelists today? And I think this is a very productive conversation. Thank you so much, everyone.